All right, hello again. This is Ben Hitchcock Cross talking to you today. We got some stuff going on. Man, they talk about empowerment. And I don't know what empowerment is to you, but to me, it's getting a Teams recording, Ben Hitchcock Cross, and Debbie Keith. It all come out clearly in a one solo recording. So hey, see what's happening now today. Man, that was a terrible introduction. Way better one is this. We've got a Court of Appeals decision from the state of Wisconsin. That means it's law for everybody in the state of Wisconsin. This is the law, the new law here. And this we're going to go through this decision. It's being touted as a big win for Moms for Liberty because that is the plaintiff here. But I think it's a big win for everybody because the antidote to free speech is more free speech, not defamation. We have a couple things that we're going to have to sort of put in quotes here, so let's do that now. Number one, this is a appeals court decision from the First District Court of Wisconsin. I practice before them. I vote for them. I know of some of them. Yada yada. I would say that you could not expect me, even if I were to criticize this decision, you need to understand that I would probably not be the best person to criticize the First District Court of Appeals. Number two, you need to know that we've got the defamation suit against us, deliberated with because of our activities here, Debbie Keither and I. So this is Calvin Furman, administrative law judge, subordinate to Maria Seltzer, employee of Governor Tony Evers, is suing us. And this is sort of the question here. There's three words that are still up for discussion. Whether or not Calvin Furman's make his exit survey to the board of directors, whether that constituted a coup, whether that constituted a plot or a conspiracy. I fair enough. Whether it's capable of either one of those three things being true or false with regards to that activity. That is sort of the legal question that is yet before us, and one obviously I'll have on my mind. So, if you made it through all that, welcome, welcome, welcome. Here we go. Take that. One of the professionals around here. Court of Appeals, October 28th, hot off the presses, 2025, state of Wisconsin. So, I've said this before, but let me say it again. In Wisconsin, we have what's known as a unified court system, and one of the things that means is that anything that is a published decision of the Court of Appeals is the law. The Court of Appeals cannot overturn anything touched by the Supreme Court at all. But otherwise, if it makes a decision on something new, it is the law and considered as valid as a Supreme Court decision unless and until the Supreme Court determines otherwise. And that's the case of a Fifth Circuit appeals district, Fifth Appeals District number 5 decision is as valid in the First District, where I am, as a First District Appeals Court decision is valid in the Fifth Appeals Court District in Wisconsin. All those concepts clear? Let's do it. Mary MacCudden, plaintiff, respondent. They get the extra respondent because this is an appeals court. Katie Scarlett Johnson, defendant slash appellant. I know one thing I know about Katie Scarlett Johnson. I don't know how I feel about Katie Scarlett. I'll have to think about that for a while. Is that I believe that she is the president or whatever the tippy top is for Moms for Liberty, whatever that may be. I know what Moms for Liberty is. I just don't know what I wouldn't know what I know what they are. I wouldn't care to describe them. Appeal from an order of the Circuit Court for Milwaukee County, Kashua Christie Yang Judge. Never heard of her, which is surprising because they're right across the street, but surprising for me. I need to get educated. All judges are judges. Reversed and remanded with direction. Before, the chief judge is white, and also Cologne and Donald. The J's here are judge thing. I'm not sure what PJ was. Donald J. He wrote this decision. far as I know, White and Donald, this is how it usually goes in the appeals court in Wisconsin. It's three judge panels assigned randomly, unless it's going to be thrown the heck out. And in this case, all you need is two of the three votes to have a winner. In this case, we examined whether statements by Katie Scarlett Johnson on social media, which included the terms bully, lunatic, woke, God complex, and white savior, in alleged reference, I'll add that, to Mary MacCudden, are actionable as defamation. We conclude that Johnson's statements are not actionable as defamation. We reverse and remand to the circuit court to enter summary judgment in Johnson's favor. What does that mean? Johnson lost summary judgment, meaning the thing could go to trial. They appealed it to the appeals court. The appeals court said, no, this is not going to trial. End it now. And told it the really all an appeals court can, I take that. But they told the judge, background, MacCudden's online LinkedIn profile represented that she was an English teacher and held the position of social justice coordinator. So what are we talking about here? This is going to be culture conf at Homestead High School in the Mequon-Thiensville District. Homestead. I know it well. Know it well. In January of 2022, MacCudden submitted her resignation from the district. At the end of the school year, MacCudden left the school district but did not update her LinkedIn profile. Ooh, I wonder what the footnote says. You got. I just want to say, I think we are beyond explanations of what LinkedIn or X, and I also will just throw in there that I don't ever need to see another one of X, formerly known as Twitter, or the whole. I think we're past it, but I guess we're not. MacCudden eventually updated her LinkedIn profile in July of 2023. Now, on the other hand, this is a document of public record designed to explain the law to everybody. And I imagine a world in which not everybody understands what LinkedIn is. Okay. In October of 2022, Johnson received a screenshot from a friend of a portion of MacCudden's LinkedIn profile, which Johnson subsequently posted on social media. Johnson's post included a portion of MacCudden's LinkedIn profile, which stated that, I assume, MacCudden worked as a social justice coordinator, circled in red, and Johnson wrote, why the hell am I paying for a social justice coordinator in my district? Johnson further stated, this is just what at MTS schools needs more woke white women with a God complex. Thank you, white savior. Ooh, footnote 3. A few days later, Johnson learned that MacCudden no longer worked at MTS. Okay, good to know. Now, here's one thing I want to point out. It's based on my knowledge and understanding that there were a lot of federal money flowing at this time, and school districts were able to massively beef up their bureaucracy. Now, my understanding that the federal government would fund a position like trauma informed. This is an example I'm going to use. Trauma informed, I don't know, coordinator. Okay? You put trauma informed on it, you're going to get money. Now, I guarantee you that many school districts realized very quickly that they still had needs for deans, regular old deans. Okay? And that but we'll get to that in a sec. It's what I thought was fascinating that Johnson was calling MacCudden a white woman. That part is also fascinating. That is a white woman with a God complex. Back to what I was saying on many of these positions would be labeled as that's what you put quotes around labeled as um, DEI buzzwords, but the work would be the work that needed to get done. Okay, not all the time, but certainly I think much of the time. Okay, did those positions bring in DEI concepts and DEI Stalinism, or all for lack of better words, unquestionably, into every district that I can recall dealing in one way or the other, no question about it. But I want to be clear that I think that, and certainly in my experience as somebody who deals with some of this, some angles of this, I don't think these positions were as DEI focused as you may imagine. I definitely think by putting those buzzwords onto titles, you're attracting this kind of scrutiny from Moms for Liberty. You are fomenting culture war, I think is also another way to put it. Intentional or not, that is a clear byproduct of uh, the DEI agenda. Culture war. I think that was no doubt about it. I don't know that there's any evidence that that was expressly part of the. There may well be, but it was pretty clear from the beginning that that was always a part of the um, formula, byproduct or not. Later, Johnson added, if MacCudden really wants to promote equity, perhaps she should forfeit her job to a person of color. Okay, I get that. This is also, sorry, going back to part of what I mean about I don't understand Moms for Liberty. I don't get that. I don't get the race-based comment. Um, and what I mean is I don't understand what part of their agenda, what part of the liberty agenda does that move. I don't understand. Johnson also replied to a social media user that teachers who educate are paid a fraction of what those DEI specialists earn. I think that that is some cases true. Parents know these woke lunatics are bullies. They are bullying you into science and silence, oof, and compliance. Good teachers should earn more, get support, and feel safe. Partnered with us, partner with us, and let's put kids first. I am totally analyzing her statements right now from the guise of, because I've been writing complaints all week. Is this provable? Guess what? Nobody cares. The First Amendment, baby. Nobody cares. All right, MacCudden. What does that mean? That means, let's say you say something stupid, you stand or fall on your statement. But the government is not going to get involved and step on people's necks because they say something that somebody else doesn't want to hear. What's the solution? The solution, free speech is speech. Johnson moved to dismiss, which the circuit court denied. Relevant to this appeal, Johnson subsequently moved for summary judgment, arguing that her statements were true, substantially true, or opinions, and therefore not defamatory. Johnson also argued that her speech was protected by the First Amendment. MacCudden opposed the motion. All right. After hearing oral arguments, the circuit court granted in part and denied in part Johnson's motion for summary judgment. The court found that some of Johnson's statements were not actionable because they were substantially true. The court explained that MacCudden did work as a social justice coordinator at Homestead High School. The district paid for the social justice coordinator position, and the label that she is a white woman is at least substantially true. Huh. The court, however, held that a general issue of material fact exists as to whether woke, got it, God complex, white savior, woke lunatics, and bullies constitute mixed opinions. The court stated that the terms could imply allegation of undisclosed defamatory facts that this MacCudden abused her position of power over students and was unfit to teach. I think that's very similar to what we got going places, but I haven't prepared a comparison. It is not clear from the record whether the circuit court found Janssen's statements that if MacCudden really wants to promote equity, perhaps she should forfeit her job to a person of color should go to trial. Nonetheless, we address it below for sake of completeness. Janssen filed a petition for leave to appeal the order, which we granted. On discussion, on appeal, Janssen renews her arguments that her statements do not constitute defamation. Additionally, Janssen contends that a defamation trial would violate her First Amendment rights. We conclude that Janssen's statements do not constitute defamation, thus we reverse and remand for the circuit court to enter a summary judgment in Janssen's favor. Because we conclude that her statements are not defamation, we do not address whether a defamation trial would violate her First Amendment rights. That's because cases should be decided on the narrowest possible ground. Summary judgment is appropriate if there is no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. We review whether a party is entitled to summary judgment independently of the circuit court. Oh, I love it. Just love it to death. All right. Summary judgment may be particularly appropriate in defamation actions in order to mitigate the potential chilling effect on free speech in the press and the press that might result from lengthy and expensive litigation. We have explained that when reviewing a summary judgment motion in a defamation action, we first examine the pleadings, determine whether they state a claim for relief. If the pleadings state a claim and the responsive pleadings join the issue, we must then examine the evidentiary record to analyze whether a genuine issue of material fact exists or whether the moving party is entitled to judgment as a matter of law. Further, on summary judgment, we must draw all justifiable inferences in favor of the non-moving party, including questions of credibility and of the weight to be accorded particular evidence. A defamatory communication is 1. False statement. 2. Communicated by speech, conduct, or in writing to a person other than the person defamed. And 3. The communication is unprivileged and tends to harm one's reputation so as to lower him in the estimation of the community or deter third persons from associating or dealing with that person. Oh, yeah. All right, Mock versus Allison. Good. And they note that these elements are just starting points, and that's true, and whether there may be additional requirements depending on the status of the plaintiff and defendant. This is something that came up here, right? Whether for example, Calvin Furman has been determined to be a public figure, so the question is actual malice, right? Well, that they didn't conclude whether or not this teacher was a public person or not, because they state that it wasn't defamation. I'm back and forth I think the use of footnotes here has been very consistent and often helpful. Johnson argues that her statements were not specifically about MacCudden, but rather were more generally about the type of person who holds the position, social justice coordinator. Johnson additionally argues that her statements were statements of opinion that are not provably true or false. And that's what the finding is about here. Even if we assume Janssen's statements were about MacCudden, we conclude that the statements are not provably true or false. Thus, MacCudden's defamation claims must fail. Because the rule is this: if the challenge statements as a whole are not capable of a false or defamatory meaning, a libel action will fail. That's the true or false. That's when the judge was saying substantially true or whatever. That's what that key first prong is all about. They have to be a false statement. If it's true, then it's not defamation by definition. All right. First, Johnson, and remember the key other three terms that we are considering here today are coup, plot, and conspiracy. One more time: coup, plot, conspiracy. First, Janssen refers to MacCudden as a bully. The term bully is a subjective assessment that cannot be proven as true or false. And there is standing from a case that says so on the Ninth Circuit, finding statements which are included the term bully were rhetorically hyperbolic, including hyperbole, incapable of being proved true or false. The DC case, recent one, that says the same thing. Stating that merely calling someone a bully is simply imaginative expression. What one person may perceive as bullying, another person may describe as absurdiveness. Now let's try that with one person might describe as a coup, another person may describe as a whistleblowing complaint. What one person may describe as a conspiracy, another person may describe as an exit interview. What one person may describe as a coup and a plot, another person may describe as a heroic activity. Johnson's statements do not allege any specific act or bullying or a specific victim that could be proven or disproven at trial. Okay. Second, the term lunatic is also a subjective assessment that cannot be proven true. Stating that calling somebody insane or a pitiable lunatic reflects an opinion and not a fact. Stating that the term lunatic was not actionable. Johnson's statement referring to MacCudden as a lunatic is her opinion. That's the same, guess the same. Statements referring to Furman as a plot. Oh, that's right, that's a person. That wouldn't affect. This is an action. Okay. The third, God complex, woke, or white savior are vague and do not have a clear meaning or definition. For example, some Americans define wokeness as being informed, educated on, and aware of social injustices. Others use it to mean being overtly politically correct and policing others' words. We are not persuaded that the terms are definitive enough to allow a jury to determine whether these terms are true or false. See Bauer versus Murphy. I may pause for a minute. All right. In addition, the statement that if MacCudden really wants to promote equity, perhaps she should forfeit her job to a person of color is not actionable. Hold up here. In response, I just want to see this. They point to this ABC News article saying, is woke a compliment or an insult? This is a statement about whether Johnson believes that MacCudden should do in the future, not about what she has done in the past. That is not a statement of fact that can be proven or disproven. The circuit court found that some of Johnson's statements were mixed opinions, which imply the allegation of undisclosed defamatory facts, namely that MacCudden abuses her position of power over students and is unfit to teach. This is pretty critical here from my point of view. A mixed opinion is a communication which blends an expression of opinion with a statement of fact. Communication of this nature is actionable if it implies that the assertion of undisclosed defamatory facts is the basis of the opinion. Here we are not convinced that a reasonable person reading Janssen's statements would have understood her to be implying that MacCudden abused her position of power or was unfit to teach. Whether the words complained of are reasonably capable of conveying a defamatory meaning to the ordinary mind, or whether the meaning ascribed by the plaintiff is a natural and proper one. Huh. Stating that the words must be construed in the plain and popular sense in which they would be naturally understood. Janssen was not commenting on MacCudden's teaching record or qualifications. Oh, okay, because then it would, if it's talking about her ability to teach, then it's talking about her, that's where this Bauer stuff comes. Thank you. I went on a small Bauer trip while I was gone on a pause that you may or may not have noted. And one of the things that Bauer says, which was pretty interesting, was that for slanderous statements, you need to have actual damages. Actual damages, meaning somebody said, I'm not going to associate with you because so and so said you were a jerk. Then you can get other damage. Your hurt feeling. You want to read it? I kind of like it. All right. Slander originally was not actionable without proof of actual damage of a pecuniary nature. That means money, called special damages. But by the 19th century, it was established that some kinds of slander were actionable without proof of damages, which would be presumed from the character of the defamatory language. Why it's kind of hard for state employees who haven't lost a cent of income to sue, my opinion on that. I think that's what that's saying. Which would be presumed from the character of the defamatory language. Such slander was thus actionable per se. The other one is called per quad. Consisted of an imputation of certain crimes or of a loathsome disease or affecting the plaintiff in his business, trade, profession, or his office. And of inchastity to a woman. That's gross. Why? Because it kind of implies that chastity is a woman's occupation. All other slander not falling into these seemingly artificial categories, no matter how obvious or apparent, is not actionable without alleging and proving special damages. Having proven such special harm of a pecuniary nature resulting from the action of third parties affected by the slander, the plaintiff may also recover general compensatory damages in a parasitic manner for damages to the invasion of his interest in his reputation and good name, including his own injured feeling. You get what I'm saying? Per quad. Boom. That's Bauer. Johnson was not commenting on MacCudden's teaching record or qualifications. Further, Johnson did not indicate that she had any personal experience with MacCudden or was basing her statements on anything other than what she disclosed from her LinkedIn profile. I guess the one would anything from than what Furman disclosed from his exit interview. I think that would be the analogy there. Lastly, we note MacCudden asserts that Janssen's post had negative connotations. That fact, however, that a statement is negative does not standing alone constitute defamation. Let me say that again, Wisconsin. The fact, however, that a statement is negative does not standing alone constitute defamation. Defamation occurs only when a statement asserts a false statement of fact. The light was green. I knew it to be red, though. You see what I'm saying? He's a can't say he's a bad worker that falls outside that count. This is not count. He's a terrible amateur baseball player. But I've seen him hit 20 home runs. I don't know. Okay? That's what we're talking about. Fact is the key. That's that key. Falseness and fact are the key concepts here. Here, Janssen's statements cannot be proven true or false. Therefore, for reasons above, we agree with Janssen that her statements are not actionable as defamation, and we reverse and remand for the circuit court to enter summary judgment in Janssen's favor. By the court, order reversed and remanded with directions not recommended for publication in the official reports. So everything I said about the law is out the door. This is not the law. The majority reverses the circuit court's denial of Johnson's motion for summary judgment in this defamation action brought by MacCudden's post. The majority on the grounds that opinion are vague and do not have clear meaning or definition. I do disagree. I would conclude, as the circuit court did, that there's a general admission of material fact as to whether Janssen's statements are mixed opinions that imply the allegation of undisclosed and defamatory fact. While Janssen does not provide any specific examples in her post, the fact that Janssen specifically identified MacCudden and her position as a social justice coordinator in the post imply the possibility that Johnson is aware of but has not disclosed specific defamatory fact. Well, maybe you can explain that more. Johnson's posts were not merely general statements that Johnson did not support public school systems having a social justice coordinator position or that Johnson found woke ideology offensive. General statements of this nature constitute opinions that cannot serve as the basis of defamation actions. Here, however, I can ignore the context that the posts were specifically about MacCudden and her holding the specific position of social justice coordinator. The contents and circumstances in which the statements were made are also to be considered. The special identification of MacCudden and her position as a social justice coordinator creates the possibility that Johnson's statements are more than mere opinion. I don't see how. It at paragraph 19. So we'll go to Terry at 19 in a second. All right, here we are. Terry at 19. A statement is defamatory if it tends to hold one's reputation so as to lower him or her in the estimation of the community or deter third persons associating or dealing with him and her. A person who claims that his or her reputation has been unlawfully damaged by something someone else has said must first establish that the words are not true and are capable of a defamatory meaning. Uh-huh. In determining whether language is defamatory, the words must be construed in the plain and popular sense, which is that they would naturally be understood. The context and circumstances in which the statements were also made is to be considered. It is not necessary that the article or statement in question be true in every particular. All that is required is the statement be substantially true. I don't understand, and I'm going to go back to what Pedro Colon says here. Okay. I would conclude area 23. 23. A majority of the statements Terry complains of use some variation of the terms rob, ripped off, cheat, victim, or scam. The media defendants maintain that these statements are opinions based in fact and are therefore not action. We agree that all of these terms, in the context in which they were used, convey statements of opinion that are not defamatory. The principle of fair comment, legal immunity for honest expressions of opinion on matters of legitimate public interest when presented upon true or privileged statements of fact. One set of quotation, although opinions are not completely exempt from the realm of defamatory communication, an actionable opinion must be blended with an expression of fact. It must apply the assertion of undisclosed defamatory facts as the basis of the opinion. The use of these terms all stem from the fundamental fact that although Terry provides us with dictionary definitions of all the words she challenges, all of which she implies criminal behavior, we note that while some connotations of a word may encompass criminal behavior, others do not. In the context of the entire news broadcast, advertisements, and websites. Okay, there we go. I'm here. We're going to go read back this whole thing again. I'm not understanding. This is the main sentence. While Johnson did not provide any specific examples in her post, the fact that Johnson specifically identified MacCudden and her position as a social justice implies the possibility that Johnson is aware of but has not disclosed specific defamatory facts. I don't understand why somebody identifying a person by their position could imply the possibility that they know some other undisclosed defamatory fact. Okay, so let's look at the negative. They weren't general statements. Okay. The context were about MacCudden and her holding of a specific position. Okay, let's look at the context. I don't understand how. The specific identification of a person and their position creates the possibility that the statements about them are more than mere opinion. Bill Smith is a jerk is not, well, how does that imply that I know that guy is a jerk? Social coordinators are jerks. Is that, if I say Bill Smith is a jerk, does that imply that I know something specific about something special and undisclosed about Bill Smith that I haven't told you? Why would we assume that the person knows more than what they said that they know? That doesn't make any sense. Right here, as far as I understand the facts that the person knew about this LinkedIn post, and that was it. I don't understand that. Right? We don't need a social justice coordinator. Okay. The social justice court. We don't need another white woke liberal social justice coordinator with a God complex. I just don't see it. Okay. Well, there we are. That is the all of the thoughts of the appeals court of the state of Wisconsin on this decision. We will have to wait of whether or not if it's going to be published or not. Highly, 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 highly persuasive. What we can. All right. Thanks for sticking with us. Keep you informed.